Good morning and welcome to the Government Contract Compliance. Does your company comply? The webinar edition, May 13th, 2020, a Wednesday for all of those working from home for the last 2 months, and it is a Wednesday. I'd like to welcome everyone to attending, and I apologize if my internet connection cuts my voice out occasionally. Please mute your phones. We will be using the chat box and monitoring questions. We will have questions at the end of each of the speakers. At the very end, one of the last slides, we will ask you to complete a survey. This is one of that's your only cost for attending this webinar, is to please help us out and track our event and complete the survey. There will be a link provided. I'm your host, Kara Vernon. I'm a PTAC procurement specialist and UCF employee. I will be your host today, and I'll be monitoring the chat box. Our presenter is Ed Kinberg, attorney with Stewart Law. He is a fellow with the National Contract Management Association. His experience, he was a judge advocate, general counsel for the United States Army when he was in the service. He has done U.S. Army Contract Appeals Division, and since '96 he moved to the Brevard County area in Melbourne and has been working within his own law practice. So he's a Florida Bar Associate and has had many successful years in practicing law, government contracting law. Ed, I'm going to turn it over to you.
We're a little new with Zoom, so it might take us a little bit to do things right, and we might glitch up a little bit. So I just wanted to warn you. I have practiced it, but it's a new experience for all of us. I'm just trying to get the slide, Kara, to move. It's not moving. There we go. Okay, this morning, we have a two-part program. I added a section from Fernando Machado, who has a cybersecurity company, and he'll self-introduce shortly. But Fernando will be hopefully becoming an assessor under the CMMC program. Once those assessor statuses are identified, people can start qualifying for it. So I thought he'd be a great person to talk to us for a little bit about CMMC, which I include under new developments. That's a development we all need to keep track of. I keep track of it on a weekly basis. But some other new developments I wanted to go over with you. One is, if you've gotten money under the Paycheck Protection Program, you make sure that you carefully account for how money spent. If you can't demonstrate that you spent 75% for payroll, more than 25% for overhead, you're going to not get forgiveness on the loan. You also can't have an overlap between PPP types of money. So if you got two different PPP loans, you may not get forgiveness on the Paycheck Protection Program. Excuse me, I'm sorry, my hotline not connecting. And also, we've changed from Dunn's numbers to Sam's numbers, which was supposed to be in place the first of the year. I recently, law firms at the first of the year, was registering my new firm, and they still gave me a Dunn's number. So I can't say that they changed the SAMI numbers, but that's what told us what is in the future for us. SAMI numbers instead of Dunn's numbers. And the people that already have Dunn's numbers over a period of a year or so will be automatically converted. And they're apparently behind because they can't get it started. There's also potential of a new item coming up called line item numbers. And I don't know if that's going to happen for real or not. There's just been talk of it. But extended line item numbers break a product into hundred parts numbers, and the webcast and the statement of work would list each item individually. Then, of course, as you all know, we moved to SAM on November 1st. It's supposed to be new and improved. I find it's the opposite. It's new, but it's actually gone backwards and more difficult to use. If any comments on the changes to new developments you want to share with us, please send in a chat note, and we'll be glad to go over what you have. If we can't go over it today, we'll send it out to everybody. I'm now going to turn it over to my good friend Fernando Machado, who's going to bring us up to date on the latest CMC developments. Here, I'm going to give up remote to Fernando.
Good morning, everyone. All righty. I hope everyone's having a great morning. My name is Fernando Machado. I'm president of CyberSec Investments. And today we're going to discuss what is the cybersecurity maturity model and how it may apply to your business. Now, just a little bit about our organization. We are a cybersecurity consulting firm. We specialize in compliance, specifically the NIST 800-171 Controlled Unclassified Information Standard. We help organizations by performing gap analysis and figuring out where they're at and develop a plan on where they should be and help them get there. Our focus has been primarily within the DoD. We've done work for the Army, the Air Force, and the Navy. We are a service-disabled, veteran-owned small business. But most importantly, our organization is certified with the industry's top cybersecurity certifications. Kara, can I have you go back one slide, please? Thank you. So what is the CMMC and how does it apply? Okay, can you go back one slide? I think we're right there. Thank you. So what is the CMMC and how does it apply to you and your organization? So the Cybersecurity Maturity Model certification was modeled after the CMMI. There's 5 certification levels in the CMMC. The model was developed by the Department of Defense to specifically address the defense industrial base's cybersecurity deficiencies. The model is a collection of various standards and requirements basically rolled into one. Now, this is where things get interesting. Under the current NIST 800-171 requirements, anyone handling CUI must apply all control requirements and self-attest that they are indeed in compliance with those requirements. Well, under the new CMC, third-party assessors will come and certify that you are indeed meeting those requirements, so self-assessments are no longer going to be allowed. Next slide, please.
While we're switching slides, I wanted to note that this is going to apply to subcontractors at all levels. It flows down to everybody.
Can we go back one slide, Kara?
There you go. Is that the right one? Katie Arrington?
Yeah, the Katie Arrington one. All right. So Katie Arrington is the Chief Information Security Officer for the Acquisition and Sustainment in the DoD. She is heading this effort. At an event, Katie said adversaries such as nation-state actors weren't targeting the Lockheed Martins and Northrop Grumman's of the world because those organizations had the resources and capabilities to defend themselves. Instead, adversaries are now going after those businesses in the defense industrial base because they're the most vulnerable, and this was the basis for the creation of the CMMC. So here's the CMMC timeline for this year. At the end of January, version 1.0 of the CMMC model was released. And then in March of this year, version 1.02 was released with minor changes. And this is the current version, which is why I have it highlighted in red. Later this summer, you're going to see the CMMC requirements begin to pop up in RFIs. And by November of this year, you're going to start to see the CMMC requirements in RFPs. Since most of the work has been remote, there will be not much of a delay due to the COVID-19. That being said, Katie Arrington has said that there's a possibility initial audits may be delayed by about 2 weeks. All right, next slide.
Fernando, we have a little bit of problem.
Yes, ma'am.
Slides. Justin, the PowerPoint is not showing on the screen except in the upper right-hand corner where Fernando's photo is showing. So how can we fix that? Justin?
I'm seeing the PowerPoint on my screen.
You can see it okay on your screen?
Yes, but it keeps kind of changing. I don't know who else is controlling it, but it keeps moving.
It appears it has a mind of its own because it. Okay, I am getting people are saying that it's coming in well for them. So Fernando, go ahead and continue. Please send me a message if you're still.
All right. Okay, yeah, no, I can hear you. I'm just trying to get to the next slide here. All right, there we go. So, go back one.
Back to Katie.
All right, so here's an example. No, the one after this timeline.
This one?
Right here. Yep, the levels, yep. So here's an example of the CMMC levels I mentioned in the previous slide. The levels are cumulative. So for example, if you're a level 1 organization, you will perform the 17 practices. Once you go to level 2, you'll perform the 17 practices for level 1 and an additional 55 practices for level 2. So it keeps building up the higher you go up. Next slide, please. So the CMMC is going to consist of 17 domains. Each domain has practices that you will need to meet to become compliant. So for example, under the physical protection domain, one of the requirements is that visitors will need to be escorted when they're visiting your facility. Next slide, please. Now you're probably wondering, what data does the CMMC apply to? And the answer is twofold. It's going to apply to controlled unclassified information and federal contract information. Next slide, please. So under the CMMC level 1, the focus is on protecting federal contract information. Now I'm all about giving examples because I think it helps people relate to how it ties to them and their businesses. So let's say you're the owner of a landscaping company called Lawn and Order Lawn Care, and you're awarded a contract to provide landscaping services at Patrick Air Force Base. That is considered federal contract information, and it must be protected by implementing the 17 practices in CMMC level 1. Next slide, please. Now, under CMMC level 2, the focus is on protecting federal contract information from those that can directly influence the CUI environment. So let's say you're the owner of the Clean Berets cleaning company, and you're awarded a contract to provide cleaning services for MacDill Air Force Base. Although the cleaning personnel may not have logical access to the CUI or FCI environment, they still have the potential to directly influence the CUI and FCI environment because they have access to the rooms and buildings. And so in this instance, the cleaning organization must implement the 17 practices from CMMC level 1, as well as the additional 55 practices in level 2. Next slide, please. So under CMMC level 3, the focus is on the protection of the CUI environment. And it's any organization that processes, stores, or transmits CUI. So let's say you're the owner of Acme Aircraft Manufacturing. You're awarded a contract to produce aircraft parts for Cape Canaveral Air Force Station. If your contract has CUI, the DFARS 252.204-7012 clause will be stated in your contract. Since your organization processes, stores, or transmits CUI, you must implement the 17 practices in level 1, the 55 practices in level 2, and the 58 practices in level 3 to be certified for a total of 130 practices. Next slide, please. So what is CUI? CUI is information that requires safeguarding, but is not classified under Executive Order 13526. And so in the upcoming slides, I'm going to include links to the National Archives, which goes into further detail on CUI and the different categories it pertains to. Under the defense category, for example, it applies to controlled technical information with any military or space application. So research and engineering data, engineering drawings, data sets, technical reports, and technical orders. Those are all examples of controlled technical information. Next slide, please. All right, so to wrap this up, here's some takeaways to keep in mind. The DoD has identified that there are over 350,000 contractors and subs in the DIB. Assessors will be limited. All contractors and subs will need to be CMMC certified in order to maintain and or be awarded a contract with the DoD. So at minimum, a contractor or a sub will be certified at CMMC level 1. Now, there aren't that many assessors, and this new requirement is going to make the demand for assessors even higher. I urge you not to wait until the last minute to get prepared, or you run the risk of not being awarded or maintaining your contract. And as I said earlier, these requirements are going to begin to appear in RFPs in November, and the cost of certification will be considered an allowable cost. So you're going to be able to get reimbursed by the DoD for the cost of certification. Next slide, please. Now, I've included a few important websites here for you guys to check out. The first one is the official CMMC website. They have a very good FAQ section. I highly recommend you check it out. The second website is the official CMMC accreditation body, which will be training assessors like myself to come to your organization and get you certified. And the last website is the official National Archives website, where the CUI is discussed in further detail. I'd like to thank everyone for their time, and if you have any questions, I'm all ears.
Thank you, Fernando. Ed, back to you.
And I am requesting control, Kara. To our listeners, I want to thank you for being here today. Our slides may be a little bit slow in turning because we're using 3 different computers in 3 different locations, and they don't always seem to respond as fast as they would if we were at one location. I want to thank you, Fernando, for a great summary of what CMMC is. I just want to mention a couple of CMMC points and why I included it in this compliance program. CMMC is going to be a mandatory flow down clause to all the slowest subcontractors. Confidential defense CUI, confidential unclassified information, is going to be in effect in virtually all contracts. So you're going to have a flow down to everybody. So no matter what your size is, you're going to need to get on board at least level 1. And today, the difference between that and what we're talking about today is compliance. And some of these compliance things I'm going to be talking about are not mandatory for small businesses, so you don't have to do them. But our recommendation is that you comply with all of the standards, the same as a big business would. It's not complicated or expensive, as you'll see during the course of our presentation, but it enhances your status as a bidder for a subcontractor or as a supplier, because you'll show that you've got you're meeting the same standards that your large contractors are meeting, and they don't have to worry about you, because the prime contractors are all responsible for ensuring that you are properly compliant with the ethics and certifications. Now, whenever all of you are registered, or most of you should be registered with SAM. If you're not registered with SAM and you're doing government contracts, you need to get registered, because you cannot get awarded a government contract unless you have a SAM registration. And the SAM registration can take several days, because you have to wait for them to send you first. You have to wait for them to send you a cage code. Without the cage code, you can't continue your registration, and you can only get the cage code from the government. If you need a DUNS number, you go online to DUNS, type in what is my DUNS number, it'll take you to the DUNS site, and much to your surprise, you will find that you have a DUNS number, or one will be assigned to you. But without the DUNS number, you can't progress your registration. And without the cage code, you can't complete the registration. So I just wanted to mention that. Now, another issue, Fernando brought up a good point, that the costs for CMMC compliance are allowable, but the amount of the type of allowability is still an issue. If you have a contract that's changed, you have an existing contract and a change order is issued to add CMMC, you may be able to get paid for the direct cost because it's a new requirement during an existing contract, just like any other change requiring you to do something more than you were doing before. If you're bidding on new contracts, and this is just my guess, no one's really talked about this much, but if you're bidding on a new contract, you're going to be allowed to include that in your overhead pool as an allowable cost, but that doesn't make it necessarily a direct cost. And we're still waiting for guidance on that issue, but my guess is that's what's going to happen, is if you have a change order to an existing in-place contract, then it will be direct cost, and if you're bidding new contracts, it will be allowable cost included in your overhead pool, and DCMA won't ding you for including those costs or disallow those costs. Those are important, a couple of important CMMC things to remind you of. If you have questions while we're going along, please put them in the chat box. I'm trying to keep an eye on the questions while we're going through, and I'll try to answer them in close to real time if I can. In addition, after the program is over, if you have any questions, if you send them to Kara Vernon at ucf.edu, which is her emails in a recent recent chat message, she'll get the questions to me, and we'll send them out to the questions and the answers out in writing to the entire group. Now, what we're going to be discussing today is what is compliance. Compliance means, and I know it seems kind of obvious, but it means complying with certifications. And there's a lot of certifications, and we're going to go over some of them today in your SAM registration. The problem with certifications is, it's not a problem. The issue with certifications is that if you certify something and you don't do it, then every pay request you get could be considered a false claim under the concept of implied certification because you aren't doing something that you promised you would do in return for the government money. And false claims are not good things. False claims, we'll go over those a little bit on a later slide. There's an interesting case out in California. It's not decided yet at the trial level, but the prime contractor, who's one of the bigs in the industry, has been certifying compliance with the cybersecurity regulation, the current one, which requires you to have a plan to implement everything, and in fact, did not have a plan to implement everything. And the cybersecurity guy for the company kept complaining about them not having a plan for doing it. They wouldn't listen to him. The individual eventually filed suit under the False Claims Act, and it went up to the Court of Appeals, and the Court of Appeals found that you could proceed with that case because it was appealed based on the lack of cause of action, that they couldn't be sued for that. The Court of Appeals found that they had the FAR clause in their contract, they were implied to certify with it, and it was a fact issue as to whether or not they were in fact making good faith efforts to comply with it. So that company is facing a very, very expensive lawsuit on false claims. So that's just one example with the cybersecurity stuff, but that applies to all of them. Somebody asked, how do you get certified under CMMC? And the answer is, once they get the assessors licensed, people like, I believe Fernando may become an assessor, their companies will do the assessment and you'll pass or no pass. But one of the things Fernando pointed out, which is very important, is don't wait for them to have the assessors. Get your system lined up, hire a consultant if you have to, and be ready for the CMMC assessor to come in so that you pass the first time and minimize any delay. But right now, if you go to the CMC Advisory Board, they'll keep you up to date on the latest, and there was a link to it on Fernando's slides. They'll keep you up to date with the latest in status on the assessors. So one of the compliance is complying with certifications, complying with FAR clauses, and appropriate business systems, all of which are going to be discussed in more detail later. I'm sorry, just a second, I just lost my chat window. So going on to the next slide, I'm going to try and transfer this myself, Kara. To the next slide. This is where the False Claims Act and other issues come into play. When you do things that are wrong for the government, there are 4 different ways the government has of punishing you. One is contractual. If you are required to have an ethics system and don't have it, or aren't complying with other business system requirements, they can suspend a portion of your payments until you get in compliance. You still have to continue to perform, but they're going to take, I believe, and my number might be wrong, up to 20% of each month's payment until you get into compliance. Always a bad thing to happen when you don't get all of your money. You can also delay performance because you have to get geared up into it, gear up to build the work in before you can get paid. You know, under the COVID stuff, it's interesting. I don't know what's going to happen. It's kind of a blank slate right now. But if you get a change order requiring you to implement certain safety procedures, that's probably that will be an allowable cost. You need to do 2 things separately. You need to separately track all the costs related to COVID compliance, and you also need to segregate the costs that you are getting reimbursed from through either an emergency disaster loan or paycheck protection, because you can't put those in request for equitable adjustment also. All you get is the excess cost over other stuff that the government paid. It's a new issue. Nobody really knows how that's going to play out. Administrative issues are probably the most immediate impact. That's a suspension or a proposal for debarment or debarment. The difference between debarment and a proposal for debarment is a proposal is basically the same as the suspension. As soon as the agency issues that letter, suspension or proposal for debarment, you can no longer bid on any federal contracts. You are barred from bidding. Now you'll continue to perform contracts that have been previously awarded, but not bid anything new until you get that suspension lifted. And one of the things they're going to require to lift the suspension is for you to develop an ethics program. And I've had a client that's very kind of interesting. It wasn't even a federal government contractor. It was a city contractor, but they were using federal money that was doing it, that was paying for the contract. So the Davis-Bacon Act applied and the Federal Pay App applied. And when you look at the standard federal pay application for construction, there's a statement on it that says that you certify that all subcontractors and suppliers included on the previous pay request have been paid. Not on the current one, but on the previous one. And he was actually suspended. He was in compliance, but he was actually suspended for non-compliance by a DOJ attorney that misread the clause, thought that applied to the current pending unpaid pay request. It took us close to 8 months to get him unsuspended and get him back on track so he could bid on government-funded work again. And he had to come up with a compliance program, an ethics hotline, and all kinds of garbage, all kinds of compliance materials. So it wasn't hard to do. It was just time-consuming. The third is the False Claims Act. The False Claims Act is really interesting. And this is what happened in the cybersecurity case in California that I was telling you about. The False Claims Act gives every individual in the United States the absolute right to bring a lawsuit against you for filing a false claim. And they file that lawsuit in the name of the government. So really it's the government as represented by Joe Smith. Then death is filed under seal, so you don't know about it. While it's under seal, the Department of Justice will look at it, and if they like the claim, they will then assume responsibility for prosecuting it, which takes the financial burden off the individual that filed the claim initially, and also adds to your complexity. But you've got to be very careful on these False Claims Act claims can be filed by anybody. I'm sorry. The chat thing popped up there we go. So that's the False Claims Act. In addition to the False Claims Act, the person that brings the false claim gets between 15 and I believe 22%. They change the numbers from time to time on the percentage you get. So on a $4 million claim, if you get 20%, you as the bringer of the complaint get $1 million out of that settlement with the government. So there's a strong incentive for employees that are dissatisfied internally to bring a False Claims Act claim against a company that won't comply. Here, I'm in Brevard County, Florida, and we've had one claim. We've had several false act claim cases, one which was brought by the comptroller of a medical organization that was complaining about improper coding to the medical organization, and they wouldn't correct it. He brought a False Claims Act claim against them. They ended up settling with the government, which included implementing an ethics program for $4 million. And this guy got somewhere between 15 and 22% of the $4 million. So there's a strong incentive for people to bring False Claims Act. If you have dissatisfied employees that are complaining about you not doing something that complies with your certifications, you at least need to look into it and either come up with an internal memo saying, we looked into this complaint and we are in compliance, or we found out we're not in 100% compliance, and this is what we did to fix it. Prevent Brian asked everybody if there will be detailed step-by-step worksheet or workshop on how to prepare for compliance assessment. And that is something we can do in the future, but it's really not that complicated. Discussing a lot of the compliance issues as we go through it. If you have any more questions, please feel free. I'll answer the questions I see in the chat window as I can do that, as they come up. Now, the False Claims Act, civil, also leads us into criminal, because the False Claims Act has both civil and criminal penalties. So if you as a company representative are knowingly engaging in a False Claims Act, and they find that out, false claims violation, and the government finds that out because of a false claims civil lawsuit, the government can also file criminal charges against you. And I've actually seen that happen. When I used to do contract appeals for the Department of Army, I had a False Claims Act case that involved the False Claims Act. And in that case, the individual pled guilty in return for lifetime debarment, and we were still prosecuting. They were still getting the amount of fines to be done. He went to jail for that false claim. I have an interesting case in Jerry Lewis Truck Parts. And first, I was really lucky I get to talk to Jerry Lewis during a deposition, but it turned out it was a different Jerry Lewis. So that's the 4 actions the government can take against you: contractual, administrative, civil, and criminal. And all of these are kind of unique to government contract law. I'm going to try to switch to the next slide. There's a little bit of a lag time, so I might go up 2 slides by mistake.
I forwarded it. Oops.
So what are the basic elements of a compliance program? Go back 1, please. Integrity, honesty, maintaining an honest business relationship, and fairness and competition. Now, some people will say that all procurement systems have some corruption in them, and that may be true, but I do believe that the United States system is the least corrupt and the most aggressive about cleaning up corruption when it comes across it. So it's important to be able to explain that you're operating, that you have integrity, which we'll see later in an ethics statement, that your company is honest in fact, that you have honest business relationships, and you have fairness and competition. Kara, can you go to the next slide, please? I think it works faster when Kara does it. Yep. So what's Ethics 101? This is a great book by John C. Maxwell, published in 2001. It's a tiny book, maybe 40 pages, but I strongly recommend you read it and keep it by your desk so that if an auditor ever comes in, you can say, hey, this is the core of my compliance program. But really, Maxwell has one compliance principle. If something does not feel right or something you would not want a competitor to do, don't do it. That's his basic point of ethics. He believes that one point pretty much covers everything you need to know about compliance. I strongly recommend that you read this book. You know, we see, when I was in the military, we used to talk all about, if you don't want to read it in the Washington Post in the morning, or the New York Times, or the Wall Street Journal, don't do it. And that was a good guideline also. Unfortunately, a lot of people in the military don't seem to follow that anymore, but that's a good guideline in your life, is you don't want to, if you're going to be embarrassed about something or worried about something's going to harm your ability to do business, if it shows up in public, don't do it. Pretty simple rule to apply. Next slide, Karen. Okay, so what are the importance of policies and procedures? They are preventive medicine. They'll hopefully, if you have good policies and procedures, they will stop your company and your employees from engaging in acts that may be unethical or violate some of the many certifications in your contract. If the preventive medicine doesn't work, you can show you made your best efforts to comply. And that's important because under the federal sentencing guidelines, and I know some of you are thinking, how the heck does the federal sentencing guidelines apply to what I'm talking about today, to my actions? Well, as I mentioned, there's criminal and civil penalties that are controlled by the Department of Justice. And the harder you try to be a nice guy, and the more you did to avoid a mess up, the more likely you are to get a lighter punishment or no punishment at all. And that's in the federal sentencing guidelines. So even though it's not a contract document, it's something that the Department of Justice uses to do it. And since we're live today, I don't know if I'm talking too quickly or not. If I am talking too quickly, please send me a chat message and I'll try to slow down. I do have a habit sometimes of going too fast. Next slide, please, Kara. Now, so what are the key compliance components? Code of ethics and training. And at the end of the program, there's a lot of hot links in this program. At the end of the program, I'm going to give you some hot links to some of the major contractors' published ethics programs. Those are good programs. They're very complex. Some of them are many, many pages. It's a good starting point to develop a program of your own, is to look at those and either adopt their program if they're your main prime, for example, of Boeing or Blue Origin or whatever, is to adopt their ethics program and make sure your employees are trained and knowledgeable in it. Trained and knowledgeable means is you actually do training once a year. And you actually have all your employees sign a certification they've done training and reviewed the program. So having a code of ethics, even though it may not be required for your size of business, is important to do. Plus periodic and documented reviews, a system for reporting suspected misconduct, which would be an anonymous system. That means somebody can drop a note in a box and say, hey, I think purchasing is taking bribes, doing kickbacks. I think QA is overlooking a quality control requirement, whatever it could be. But some way and be a good person. Number two, if you find you're out of compliance, do everything to show that it was just an accident or a mistake, and you're working hard to get, and you got yourself back in compliance, and you're working hard to prevent these kind of things from happening. And next is encouraging employees' timely reporting to government and external audits. And what I mean by that is when you're getting a government or an internal audit, an audit of any kind, your employee gets a request for documents, or you get a request for documents or interviews, that you either apply with the date that they gave you, or you contact them and give them a new date. Now, one of the things that comes up a lot in false claims issues and this is whether it's criminal or civil, it's the first time you know something's going wrong is when you get a civil investigative demand from the Department of Justice, from a Defense Criminal Investigation Service, saying they want to look at your documents or talk to your people. Which you need, the first thing you need to do when that happens, and I'm not doing this just, you contact any attorney, I'm not doing it to try to run a business, but you don't want to respond, you want to respond to it timely, but you don't want to respond to it without legal advice, because now, once you've gotten that civil investigative demand or subpoena, you are now the subject of a federal investigation that may be civil, or may be criminal, or may be a combination of both, and you need assistance. A criminal lawyer is not sufficient. Criminal lawyers aren't familiar, a lot of times, some are, but most aren't, unless you go to the largest firms in DC, aren't familiar with the civil side of it, and the civil lawyers sometimes aren't familiar with the criminal side, but the contract attorneys, the specialists, like those of us out there, are familiar with whether or not you did is right or wrong. The advantage of contacting an attorney early is, one, you can get an extension to the date. They always request an unreasonable amount of documents in an unreasonably short time. And you can get an extension on the time, and you can get them to pare down the amount of documents that they're requesting and the location that they're requesting their documents. One of the key things to keep in mind is, if you ever have to do this, is, and I can't tell you how many times I've seen clients do this, do not let them take or give them original documents. Agree to produce everything, agree to copy everything they want, but give them copies. And this is another thing I've seen clients not do. If you give them copies, keep a copy of everything you gave them so you can show that you did what they're supposed to do. You gave them what you're supposed to give them. And in full cooperation with investigators. I had an interesting case one time where a client was charged with providing, my client was a supplier. He got his stuff from another supplier, some Samsung phones, and they were charged with providing fraudulent, fake phones, fake Samsung phones. When the investigator contacted us, we fully complied, gave them all their information, and were able to get out of it with a very short suspension and entering into a compliance agreement. The other company that we bought our phones from would not comply, was fighting with the government, and their senior executive officer ended up getting arrested at an airport, handcuffed, and had his computer seized. So cooperation has a big benefit, but do not cooperate without legal advice in your back corner. Full cooperation is important, but get legal advice. Before there's any interviews or document reviews, make sure you talk to an attorney that can tell you the parameters of what they can and cannot ask. Now, somebody asked, Catherine Skrobiak asked if her company is ISO, is that helpful in complying with this requirement? We're only 6 people. I like her note, I am all of the departments in Capitol. I am all of the departments probably applies to the vast majority of small businesses under 20 people or so. But the ISO and AS certifications do help because it shows that you're trying to do what you're supposed to do, but those are not ethics certifications. So you still need to have an ethics or a compliance program. For example, ISO and AS certified has nothing to do with the prevention of human trafficking clause that's in your contract. There's an interesting clause in your contract that says that it's in all your subcontractors and flow down, and it says you should have a policy prohibiting cell phone use while driving on government business. That's probably not an ISO or AS certification thing. It's something you need to have. So, Kara, thank you for changing to the next slide. Another area that you may find yourself getting involved with, we talked about the Defense Criminal Investigative Service, the Office of the IG, Department of Justice, FBI. Go back, please. One. But also, there's another group called the Office of Federal Compliance and Policy. They enforce labor laws, and they can conduct their own investigations in the Davis-Bacon Act, the Walsh-Healy Act, and whatever act you have, the discrimination laws, overtime laws, they support all of that. And all it takes is an employee to complain about it. And you don't have to even be a government contractor to get in trouble with the OFCCP. The Department of Labor, for example, I have a client who's a small local electrical contractor that does no federal stuff, who's currently going under a DOL audit because he believes somebody complained about him not paying overtime because he doesn't pay for the time to drive the company vehicle back from the work site to the office. And the rules on that are a little bit unclear. If it's a company vehicle that they're driving back to the office to turn in, then they should probably get overtime for it. But an exception is you can have a written agreement with an employee that they don't get overtime for driving back to work in the company vehicle and dropping it off. So I don't know where that's going to come out. The cases are all over the place. You can become a victim of any of these things. You see where it's got Executive Order 11246. That's the hot link, which I'm trying to activate. Can you activate that for me, Kara? Executive Order, there we go. So we're going to be switching back and forth throughout the class to stuff from the different employment regulations. I'm not going to go through all of this. But as you can see, and Kara, could you slowly scroll up, please? Employment opportunity, non-discrimination in government contracting, contractor agreements. There's a bunch of stuff in there, and you unfortunately need to be familiar with the labor laws. Now, some of these don't apply to companies under 50. Some do, but you need to know what they are. The most important one being the overtime, and the important two being overtime and independent contractor versus employee. The independent contractor versus employee is particularly important because if you don't play that card correctly, your independent contractor could be considered an employee, and if they consider it an employee, then you haven't paid their taxes correctly, and they may be entitled to overtime. You see that talk, a lot of that discussion in regard to Uber and other services like that, where they're trying to get to be made employees, and that's why they are. Also, if they're an employee and you have benefits like healthcare, they're entitled to those benefits, but they aren't entitled to them if they're an independent contractor. So the two most important things you need to know in the labor area is, are you properly paying overtime, and are you paying, properly paying overtime, and are your independent contractors really independent contractors? And independent means independent. Set their own hours, provide their own tools and equipment, pretty much they could choose to work for you or not work for you, stuff like that. And this varies in each individual case. I couldn't tell you a general rule, but that's the basic rule. Now, another question from Anjum Kershid. We are a small business of 18. Do we need these certifications if we do government contracting? Yes. When you put in your SAM, when you registered for SAM, if you registered properly, you certified to a bunch of stuff. You know, I'm not a government contractor myself, but I did register my firm for SAM just so I could see what you guys go through. And one of the things you go through is you click on a bunch of certifications. You recertify them sometimes when you bid them. What I did is I actually printed out all the certifications that I agreed to on the SAM website and read them, so I could say I knew what they were. So you do need to comply with certifications, not necessarily ethics requirements if you're small, but certification requirements you do. Catherine Skrobiak asked, what area of law do I practice in? In other words, if you have a problem, what sort of attorney would you be looking for? I practice in both government contracts and commercial contracts. This is, and I did government contracts with the Department of Army, both on the fraud side and the contract compliance side. I'm not saying I want you to call me, though I would like that, but you do need to make sure that your attorney has experience in government contract law and they've been practicing that area. And in the civil side, in the case I mentioned earlier where the gentleman got suspended from government contracting had a city contract, he just used a criminal lawyer. And when they settled the criminal case, which was basically he paid a penalty and they dropped the charges, they didn't take into consideration the civil side of it. So after he settled the civil side, the False Claims Act side, he got separately suspended because he had admitted to a violation. His criminal attorney didn't know that the suspension was in there as a possibility, because everything needs to be taken care of. So my rule of thumb basically is if it's criminal, get an experienced criminal attorney. If it's government contracts, get an experienced government contracts attorney. And if you have an attorney that's a general corporate attorney, ask them to consult with the government contracts attorney if they don't have experience. Now, some general practice attorneys do have, like we do a general practice also with business law, corporations, LLCs, partnerships, teaming agreements, all that other stuff that goes into being a business. We also do government contract law. So you need to check that. And if you're doing teaming agreements or NDAs on a government contract, I'd recommend you use an experienced government contracts attorney. Now, these rules also apply to nonprofits. We had a nonprofit here in Brevard County that also got hit with the False Claims Act. They had misused operating funds to purchase a building on a lease to buy thing where the lease payments actually became the purchase payments. I don't have any details on the case personally. All I know is that they settled the claim and they closed the nonprofit and they lost their building. So it does apply to nonprofits. Here, next slide, please. Now, where do the primary rules for compliance come from? Federal Acquisition Regulation, FAR, and its supplements in the Department of Justice Criminal Division. And of course, the primary rules are the Federal Acquisition Regulation. And hopefully, thank you for going to that. Stay on this page first. Excuse me. There we go. If you stay on this page, please, Kara. The Department of Justice really only comes into play if you haven't complied with the Federal Acquisition Regulation, which has various requirements. Can we bring up the Fed Acquisition Regulation slide again, please? Connection. And for those of you that got the PowerPoints, these are all hot links, and by using Control and left click, you can open up any of these regulations. One of the places you should have bookmarked on your desk is farsight.hill.af.mil. And Kara, can you reopen that one? This takes you to all the regulations by all the various agencies. Go back one page, please, on this one.
On the internet?
List that we're going back to, up in the upper left-hand corner is the Federal Acquisition Regulation. If you click on that, it will take you to an index of the Federal Regulation Acquisition. But it's also got the DFARS, which is a defense supplement. Go back page, please, and stay on that page. Okay, but it takes you to all of them. The AFARS, Air Force FAR supplement, defense, DUAU, I'm not sure of. SOFARS is the Special Operations FAR supplement. TransFARS is the Transportation Department. Agriculture is AGCAR. And when you're dealing with any of these agencies, they're going to use supplemental clauses. If you see a supplemental clause that comes out of their specific agency supplement to the FAR, you need to comply with those FARs. I did have an interesting case one time where a client was bidding on a national security agency contract, which used to be secret, but the bids are now public, or some of the bids are now public. But one of the requirements was to comply with certain NSA FAR supplement clauses, which were all held in a controlled classified database, and you couldn't get access to the database unless you were an approved NSA contractor. So the best he could do was cross his fingers and hope by reading the titles of the clauses that he understood what they are and that he would be in compliance with them. Thought it was kind of an interesting quandary. But most of these, except for as far as I know, the NSA FAR are public. I don't know about special ops. I've never had to look into the special operations FAR. But this is the place to go. I gave you the Hill site regulation. This actually took me to acquisition.gov And that's got this list of everything. And that's what I recommend you do, is you keep that as a bookmark on your home screen or on your computer. If you ever get audited, you can say, hey, yeah, I pay so much attention to the FAR. I keep the FAR and the DFARs, which is Defense Federal Acquisition Regulation Supplement, right here on the top of my desk. I like to do that. When I was in the Army, we had a big deal. Ethics obviously was a big deal. And good writing was a big deal. So we always kept Ethics 101 and plain English for lawyers on our desks. So the senior JAG officer ever came through, they would see those, they would look for them. And they'd say, well, I'm glad to see you got your fundamental texts that you need on your desk. Those were hard copies back then. You don't want a hard copy of the FAR for two reasons. One, it's huge, and paper copy is very small print. And two, it changes all the time. Okay, let's close this window and go back to the slideshow, please. Great. And the other thing is the Department of Justice Criminal Division, and let's just open that up for a second, Kara, and take a look at that. And while that's open, I want to note that Kara is recording this session, and it will be posted, I believe, on the PTAC website a few days after the program. So if you want a copy of the webinar as presented, you can get that from Kara, or it'll be available, I believe, on YouTube. Is that right, Kara?
That is correct.
Okay. So, and this is kind of a new format for the PTAC. We usually do these in live, but I think we're going to do more like this because the turnout for these things is really impressive. We have, I think, some 80 some odd people today, the program. Department of Justice Civil Division, Department of Justice Criminal Division, Kara, if you go back there for a second. Is got an evaluation of corporate compliance programs. I know if you're a small 5 or 6 person company, you may not want to worry about this, but if your company is growing, it might be something to look at. And again, the website is obviously there in the link, and this is a program that constantly gets updated. This program, let's see, it doesn't show the page count. It was 19 pages long and really boring, hard to read, and not of much interest to non-lawyers. But it's something good to read, and again, have posted on your desktop because you can say, hey, I do my best to keep up with government recommendations on compliance. And also, keep in mind that even when you aren't required to have ethics program, the fact that you have one makes you, your product or service, a better sale to your primes, because you can put that in your proposal is, I am in full compliance with the DFARS ethics requirements, even though I'm not required to do so. So let's go down, take the screen down, please, and go to the next slide. Okay, so basic FAR provisions are in part 3, improper business practices and under practices and ethics. We're going to kind of go over some of those clauses, not all of them, and not all of them in detail, but I wanted to get you familiar with them. The first group, next slide, please. The first group has to deal with improper business practices under part 3. The part 3 part, you are certifying to, no matter what side you are. These certifications are all in SAM. But I want to read this slide out because it's so important. Government business shall, when we see a shall in a government regulation, that means no exception, shall be conducted in a manner above reproach. And the fact that the government may be below reproach doesn't excuse you from being above reproach. Again, you don't want to read in the New York Times or the Wall Street Journal or nowadays on a website that you've done something or accused of something you didn't do. And except as authorized by statute or regulation with complete impartiality. That means the government has to be completely impartial in its dealings with you. They can't favor one contractor over another, both in the evaluation, the bidding, and the performance side, with preferential treatment for none. Transactions relating to the expenditure of public funds require the highest degree of public trust and an impeccable standard of conduct. The general rule is to avoid strictly any conflict of interest or even the appearance of a conflict of interest, which is what catches a lot of people, the appearance of a conflict. As you can see from the news, there's a lot of people in the government that have forgotten about the appearance of a conflict in doing business. While many federal laws and regulations place restrictions on the actions of government personnel, official conduct must in addition be such that they would have no reluctance to make a full public disclosure of their actions. So that's where when we talk about not reading it in the New York Times or on a website or Instagram nowadays or Facebook, that's what we're talking about. Is you don't want to do anything that if you read about it online, would be embarrassing or hard to explain. That's really the simplest way to put it, going back to the Maxwell Ethics 101 part. Next slide, please. Now we're going to go over some of the specifics in part 3.101. And really what I would recommend for all of you is that you do two things at a minimum in being government contractors. One is you read the definitions in, I believe, part 2, so you know what everything means in the FAR. And 2, you read part 3 and understand it so you can tell what it says. Now, we'll go back to the, let's minimize this for a minute, please.
Back to the slide.
Back to the slide. Or I can do it maybe. Sorry for a little. So here I listed many of the key clauses that you have to understand and comply with. Number one, the first one is 3, back one place, please.
Which one?
The list of clauses. The first one you have to comply with is FAR 3.103. Back one slide, please, Kara. In FAR 3.101, I'm sorry, we're trying to get these slides to go backwards. There we go. 3.103, could you activate that link, please, Kara? When you activate that link, it's going to take you to part 3 of the FAR, which we'll see in a moment. And once you're in part 3, you can break it down on the top part of your screen here, but you see the FAR part, we're in 3. We want to look at section 103, so we click on that. I apologize for the lag time. Mine's not dropping down. There we go. Now we're 3.1, and if 103 is the one I want to read, then I would click on that, and it will take me to 103. Solicitations, provisions, evaluating the certification, and the need for the certification. Well, let's take a look for a minute at evaluating the certification. We just need to wait a second for that to pop up. Okay. So these are the things the government could look at in determining whether or not you actually complied with independent pricing. But independent pricing is pretty simple. You don't want there to be any evidence that you coordinated your pricing at your level with anybody else. That doesn't mean you can't work pricing if you're a subcontractor to a prime and you're putting together a proposal that you can't work pricing with that prime. What it means is you can't work with that prime or other subcontractors to control other subcontractor prices. So if that subcontractor, if that prime says to you, hey, you're bidding 12 hours for this piece of work and somebody else bid 10 hours, that would probably be a violation of the independent pricing certification. So that's something to keep back in mind, in the back of your mind. And again, I recommend you read these clauses. And these are clauses that you do certify to. If you're registered in SAM, which you are, if you're doing business with the government, you cannot get awarded a contract without SAM registration. If you're in SAM, you certify to this. Next, go back, please, to the slide, to the PPT. Okay, let's see what works for me. I'm sorry, we're kind of new with doing this here, and the lag times are something I forgot to get around. It's not dropping. There we go. So procurement integrity, gratuities, antitrust violations. Back one slide, please. Are are all things that you have to, whoa, we got all the way to the end. So if you need me, contact me at djk@stewartlawcs, but we are not done. We need to go back to the slide with the FAR provisions on it.
Is that the right?
Sorry about the last. That's something we'll work on fixing the next time we do one of these webinars if we can. One more slide.
Forward?
One more slide back, please. Up, forward. I'm sorry, slide up. There we go. Up. Up. I was looking for the slide with all the FAR clauses in it that we were just on a minute ago. So that takes us back to the clause that we were looking at. We want to reduce that screen and go back to the basics. Because part 3 has a bunch of stuff in it. Can you take that slide, that screen down and bring up the slide again?
The slide is up, cybersecurity and compliance and associated FAR clause.
Yeah, that's not the correct slide. That should be FAR Part 3 key elements. Another one is 3.104 procurement integrity. Can we go back? Let's go back to the screen from the internet with FAR clauses. I can work through that without the slide.
Wrong screen, right?
Yeah, the screen that has the acquisition.gov stuff on it, all the FAR parts. Here we go. Okay. And then open up the procurement integrity tab.
Oops, sorry.
So again, the procurement integrity is under 3.104. So again, we're going to go back to the FAR screen. There we go. So again, we're going to go up to the top of the screen here. I'll control it for a moment, Kara.
My hands aren't on it.
Okay. We're just lag time. We're going to go to 3.104 procurement integrity and take a look at what that clause says. And that's a really important clause because that's improper business practices. And if you're going to read anything in the FAR, this is the clause you need to read. I'm not going to go over it in detail with you, but just to mention that that is a clause that you need to read. That's fun. And then gratuities. Gratuities is kind of interesting. I'll go to the gratuities. Let me see if I can get it to do it. This is the long way to get back there, but it'll show you how to do it. I'm going to go to the FAR on acquisition.gov. It'll take me back to my 3 slide. This will take me to all the FAR parts. There's 52 parts of the FAR. Each of them is difficult to understand as the other. And on the side here, and this is a little different screen, we're going to go to part 3. The clause 52, all the parts telling you what clauses to put in it are in throughout. So now we're looking at procurement antitrust violations, which is 3.3. Scroll down to 3.3. Here we go. Excuse me, 3.2, gratuities. Because gratuities is something that you need to understand. So I can do this one of 2 ways. I can either I can scroll down to 3.2, or I can go up, as you can see to here, to the part 3 select. I could select 3.2, and I can select a piece from 3.2 that I want to read. This is where you see the requirement for the contract clause. We're going to kind of walk through this clause because this is a really important one, and it's easy to violate. Okay. What are gratuities? Gratuities are when you give the government something you're not allowed to give them, which is basically anything other than a nominal value. Mostly, I think for gifts, it might be under $25. Most government agency employees will not accept any kinds of gifts. And if you're doing coffee and donuts for a meeting, and it's customary to do often some donuts for the meeting, then you can they can protect them. A lot of times you'll find government employees want to throw in a buck for their coffee and donuts just so they don't run into a 3.102 3.2 violation. So that's something to keep in mind. If a government's saying they won't take something from you, won't let you buy them lunch, even though it may be hard for the unsophisticated government contractor to understand, it's not something they can do. This is what, if you're going through it, when you read these things, and this is a clause that you are certifying to in SAM, excuse me, it's opening it up. Zoom is good, but it is not zoomy sometimes. It may be a new word, just like Google became a word. I'm sorry, it's having trouble. It tells you the specific clause, and I'm not going to waste your time trying to get to it. Here it is. Contract clause. You see in 3.202, it says you shall insert the clause of 52203-3 in all solicitations. I'm going to try and open up that clause so we can look at the language. When you did your SAM certification, you actually certified to this clause. Excuse me. It won't take me directly to that one. We're going to pass on that, but I'd recommend you look up the clause. I don't want to tie up a lot of our time because of the slow connection time with the internet. Let's go back to the slides. The next PowerPoint that says FAR Part 3, please. When we get back to the slide, and there's an antitrust violation provision, and one slide back to the FAR Part 3. That basically says you can't collude or work with other people to determine what your pricing is going to be. There's a contingent fee clause, which means that nobody other than a bona fide employee, and you have to read the clause to understand it, nobody other than an independent contractor, an employee, can be getting a contingent fee. In fact, you probably shouldn't be doing any contingent fees. Now, on the previous slide, Part 3, you don't need to go back there, Kara. Stay on this slide. That Part 3 here, like those clauses in Part 3, all have in them an implementing provision that says insert the clause of FAR 52.203-2 or 52.203-10 in all contracts. And these are in all contracts. Anti-kickback statutes, you can't pay or take money back from a prime contractor. If they say you bid $10, and if we get the contract, I'll give you back 50 cents a unit, you can't do it. You can't restrict subcontractor sales to the government. Now, under a teaming agreement, you can restrict a subcontractor from working with other primes to bid on that particular contract. But you cannot bid on that. You can't restrict that subcontractor from bidding directly on other government contracts for the same item. They just can't compete with you, bid against you on the same contract that you're teamed up on. You cannot be required. If a contractor tells you you need to sign a broad restriction saying, I will never bid on type A widgets ever again, that's a violation of this clause 52.203-6. Can we try and open that clause up, please, Karen?
52.203.
Opening that, we'll talk.
What was the number?
Opening that, we'll talk about some of the other clauses. Presenting personal conflict of interest is important. If you have a relationship with the government the person that has a relationship, like if you hire a retired colonel to do your marketing, that person can't be involved in your pricing to the agency he used to work with. They know the rules when they leave the service, they're briefed on them, and they can get ethics opinions as to whether or not a certain activity violates their standards. Here, looking at Part A, except as provided in B below, I always like that. The contractor shall not enter into any agreement with an actual or prospective subcontractor, and prospective subcontractor brings in teaming agreements, or otherwise act in any manner, which has or may have the effect of restricting sales by such subcontractor directly to the government of any item or process made or furnished by the contractor under this contract or under any follow-on production contracts. So a teaming agreement can only restrict you on bidding on the same contract. So you won't compete. If you're working for IBM, you won't go with, I'm dating myself, you won't go with Texas Instruments to bid on the same thing. And your ability to be involved in multiple teams depends on your strength in the industry. I did have a client that owned the rights to a key piece of software, and they were actually able to enter into multiple teaming agreements for the same product, but they kept their bidding teams separately so there would be no appearance of price or no appearance of collusion or coordination on price. So that's the independent, that's on restrictions of the sales to the federal government. Can we go back one, please? Or close, minimize the screen. Contact with government employees is at 3.6. And basically, government employees, and they'll self-enforce this one, or should be self-enforcing it. The government employees should not be talking to you after an RFP comes out or request for bids. Now, a lot of people misunderstand this and mean you can never talk to a government employee, but you can talk to government employees in the pre-solicitation phase. And in fact, they hold industry meetings to try and get a better idea, especially on more complex items, of what the industry's capabilities are. But that's okay. But if the only limitation would be is you take that one step further and not just tell them about your capabilities, but get them to write an evaluation factor or include your product as a required product in a contract. That could be a competition problem, and that could prohibit you from competing for the product. So you do want to watch that. Voiding and rescinding contracts. If the government finds that you did something wrong in getting the contract, they can take your contract away. Can we go to 52203-8 for a second? See if I can get it to do it. Nope, back one. Up one. There we go, up one. The other direction. Some of these slips may be because we're both on the mouse and I'm proficient with it. One more. There we go. Okay. Probably one of the most important ones is in the middle here. Probably my next slide, I should highlight this one. Contractor employee whistleblower rights and requirement to inform employees of whistleblower rights. This applies to everybody. You can't prohibit whistleblowing. You can't punish whistleblowing. You can't do anything to restrict whistleblowing, or else you will be in violation of this FAR, which could lead to a rescission of your contract, and also more advanced, more serious criminal penalties. The Contractor Code of Business Ethics and Conduct is only applies, and this is what I was talking about earlier, only applies to contracts expected to exceed $5.5 million and 120 days, but should be followed by small contractors. This is what I mean by followed by smalls. The display of hotline posters actually got mixed up, and that should have been a separate line. You do have to display the hotline posters. Hotline posters, in addition to a labor poster that tells everybody about their labor rights, have to be displayed in a common break room or area. Now in Florida, I came across an interesting company that annually and more often if required will give you a single poster-sized document that you can hang up in your break room that lists all the employee labor law requirements. So you cover them all, and as part of the service, if there's an update during the period of a year, they'll send you a new chart. I don't know what it costs. I just know we have that one in our break room, but you might want to get something like that to make sure that you have all your complied required notices for employees, for overtime, workers' comp, and whatever displayed in your break room or break area, in addition to wherever else you may have it. I like Nancy Amaro's suggestion. Go get a water break. You're right. I need that. I do have water with me, Nancy. I just get carried away and forget where I'm at sometimes. Can you repeat the clause? I said, Angela, you asked us to repeat a clause. Which clause was it again? If you could put that on there, which clause? I said no PL on it, but I don't know which clause it is. Daniel Noel asked, if you bid on a contract and do not get awarded the contract, how do you find out what the winning bid is? This helps us in becoming more competitive on the next bid we submit. And Daniel, that's an excellent question. And Kara, this may be another program that we want to do, is on debriefings and bid protests. But basically, on any contract, competitive negotiated contract, you have a right within, days might be off, 3 days or 5 days. I stick with 3 days to be on the safe side. And actually, I request a debriefing as soon as you get the notice you didn't get awarded it. You have the right to request a debriefing. Nowadays, they're most commonly doing them in writing, but a debriefing will tell you what the winning price was, price, not the line item prices. The winning price was what your weak spots were in your evaluation. And some insight as to whether or not, if they screwed up the evaluation, that you want to file a bid protest. You cannot file a bid protest in negotiated procurement, request for proposals, same thing, unless you get a debriefing. So even if you win, most attorneys recommend you request a debriefing so you can get some insight into how the government read your proposal. Because even with a winning proposal, you find there's always weaknesses identified. So if you have evaluation factors, then you request a debriefing. If you don't feel that your evaluation factor was done correctly, or you suspect that the awardee does not meet the right status, not a small business, or not a certain status of small business, that you can challenge that. And I have had successful challenges on that. Protests for substance, for evaluation factors, protests for size are two different things. One goes to the Department of Labor, one goes to the Government Accountability Office, or the the Court of Federal Claims. But you can challenge those things. And you are right, they're not required in FAR 12, Part 13. Those are sealed bids, but in sealed bids, they have to publish the bid list. So you can at least see what the low price was and how you fell in. So thank you for mentioning that. You do, Daniel, no, you do request a debriefing from the point of contact you submitted the bid to, which is typically the contracting officer. So you do that. Maria Martinez asked if we're going to share the presentation with everybody. You should have gotten an email with the slide with the hot links in it. If you did, Kara can resend it afterwards, or you can contact Kara directly. In addition, sometime after today, this presentation will be posted on YouTube, I believe, and maybe posted on the PTAC website so that you can review the discussion if you'd like to. Is that correct, Kara?
Yes, that is correct. That is our plan.
Okay. So now we're looking at the contract code of business ethics we just discussed, the display of hotline posters we've discussed. Can we go to the next slide, please? And I think one of the learning points we have for all of us heading into this, I didn't keep a hard copy of my slides with me. If I kept my hard copy of my slides with me, as we're going through it and we get an internet hang up like we do now on changing slides, I could continue with the briefing. We've already talked about cybersecurity in pretty good detail. Right now, it's just 52204-23, which is kind of a best efforts thing, but you have to be able to document you had a best effort, and that does slow down to all subcontracts. That's going to change to CMMC, and frankly, I'm going to leave those kinds of discussions to guys like Fernando or others of you that may be involved in that line of business. And I'll be working that into, if I do compliance programs, I'll be working that in with a separate speaker. CMMC is kind of complicated. You know, to me, one of the most important things that impacts everybody severely is office access control. That's required all the way down to the smallest level. So if you're a small 4-person company, you're going to need a front desk or reception room or desk where people stop, sign in, and you know who's in your business at all the time. That's going to be part of cybersecurity 101. There's no cybersecurity 101, but that's basics. Fernando, are you still on board? Do you agree with that? If you're still on board?
Yeah, I'm here, and that is correct.
So everyone's going to need to have access control. What we do at our company, which isn't required to have access control, is we have an iPad at the front desk for people to sign in either as an employee or a guest. Everybody signs in when they come in, and because of the COVID stuff, we also have them click a button that says they aren't demonstrating any COVID symptoms, haven't been around anybody that is. So we now have a record that everybody that enters our workspace, we know who everybody is that enters our workspace, and 2, we know that they self-certified but don't have any COVID problems. I wouldn't be surprised if we start seeing that in future government contract clauses. So that's something you may want to think about. If you're going to do a paper sign-in, which is the easiest thing to do, you can just have that at the top of the thing. I'm signing this form to gain admission to your facility, and I certify that I don't have any COVID in the last COVID or around anybody that has it in the last 14 days. It's kind of interesting. The COVID thing's going to have a lot of changes for us, some of which will be cost recoverable and some of which won't be. If anybody's been impacted by COVID, I appreciate it if you shoot us a note on the chat window, because I might want to be interesting to address a couple of questions if you have a cost or compliance question with it. Next slide, please. Now, this is the DOJ policy on the basics. Is your compliance program well designed? I mean, well designed means, is it in a form that's easy to read and understand? What I would consider well designed is that you have a bold headline, whistleblower protection, and the statement underneath the bold headline saying whatever you want to say about whistleblower protection, whatever you want to say about contingent fees or kickbacks or whatever you want to say. But you have a written policy that explains what it is that's easy to read. Is the program being applied earnestly and in good faith, or in other words, is the program being implemented effectively? That's going to be a key factor. The only place your compliance program is in your senior officer's desk, and none of your employees have read it, signed statements that they've read it, or gotten any training in it, your compliance program is going to get very little credence. If you have a compliance program, you need to have all of your employees sign a statement saying they've read, understood the compliance program, and given an adequate opportunity to ask any questions about it. And if they won't, you make that condition of employment. If they won't do that, then they can't work for you. And then you do that annually and work that in your annual training program if you can. Does the corporation's compliance program work in practice? You actually enforce it. You do something in, say, quality control, where there's the most likely breakdown in compliance, to ensure that your QC guys don't let a part slide or a process slide. It's not 100% in compliance with the government contract. Now, Does comply in those areas? Let me back up a little bit. If one of the things you can do is your compliance program well designed and being applied earnestly, and I'm not asking you to hire our firm or even recommending it, but what you can do is once you develop a compliance program, which I think you can do on your own, is that you have an attorney review it and sign off on it annually, perhaps do the training so that you have somebody else who can say, hey, I've read their program, and if it's not good, it's the attorney's fault and not your fault. Because you're more likely to get leniency if you have a weakness in your program if some outside expert that you paid a fee to came in and was obligated to give you an honest opinion of it and messed up and didn't catch something. So that's something important to keep in mind. A lot of the large corporations do have outside counsel do annual reviews of their compliance program, including going through the training programs and checking employee signatures, just checking documentation and stuff like that. I know that's not realistic for a lot of small businesses, but it's something to think about. In your case, you may want to have the person's co-designated a compliance officer that's not involved directly in the procurement activity that goes through your program every year. And does the corporation's compliance program work in practice? Joey brought up a good point that you want to make sure you receive a post-award debrief, not a pre-award debrief. You don't even want to request a pre-award debrief. If you have a competition with doing a competitive range solicit type thing, you don't make competitive range, I'll take that back. You should request it. If you don't make the competitive range, you should ask for a pre-award debriefing on why you didn't make the competitive range. So I am clarifying that, because if you don't, you won't be able to protest it later. You just can't protest your exclusion until after the award and you requested a post-award debriefing. Briefings are absolutely critical to protecting your protest rights and also ensuring, but importantly to me, to ensuring fairness, because when the government has to debrief you, they're going to they're going to review it, and if they had a glitch in their program, they're most likely going to find the glitch, hopefully, and do corrective action. Now, a bid protest will not get you a contract award. What it will do is it will result in the agency taking corrective action, which could be anything, clarifying evaluation factors, clarifying pricing factors, clarifying confusing instructions or whatever, and then requesting final proposal revisions. Again, this is more of a protest issue, but I want to mention it. If you see something wrong in section L, which is your instructions, or section M, which is your evaluation factors, something's a slap in the face wrong, you have to challenge that before you submit your bid. It's called a patent ambiguity. If you have a patent, obvious, clear, slap in the face wrong ambiguity in either the evaluation factors, the instructions, or a conflict between the instructions and the evaluation factors, you need to bring that up by a question before you submit your proposal. And if the answer doesn't adequately clarify it, you may need to file a pre-award protest at that point, because you've got to have clarification of it, because you have an uneven playing field if you have an ambiguous instruction and somebody interprets it differently than you. Those protests about slap in the face, obvious stuff have to be done. Usually a question will suffice and clean it up, but I've also seen questions on clearly ambiguous solicitation provisions where the government's answer is really poor, and it says, see clause M13ABC of the contract. And you go back, and that's the question provision that you're asking the question about. That doesn't work. And you might have to protest it, because you will lose your rights to challenge clear, obvious patent ambiguity in a protest if you don't challenge it before you submit your bids. Same thing as if they do a corrective action and issue a new request and modify the evaluation factors or instructions. If you feel that's ambiguous or creates a non-competitive situation, you have to challenge that at that time. Next program. Slide. Yep. Matthew Sweet asked a good question. I believe it's before submitting, did you ask, you should submit a protest before the questioning period is over? And if I understand that, well, that's really what I was just talking about. And the answer is, yes, you should. And if your question doesn't get a clarification, then you should submit a pre-award protest. If that doesn't answer your question, Matthew, please write back in. I've got the chat box open on my screen. Now, to make it easier for you to understand codes of conduct, I gave you some sample policies. Some of them are really great. The SpaceX one is interesting. Let's go to the, Kara, could you open the Harris Code of Conduct, please? Now, these are all published off their website, so there are no copyright violations or improper use of information by doing this. I got all these on public websites, and these are the links to the published Code of Conduct programs. If you do a lot of work for L3 Harris, there we go. You might want to read their conduct, their program, print out a copy of it and say, that's my code of conduct. I do a lot of work for L3 Harris or Boeing or SpaceX, and I want to have a program just like theirs. Let's walk a little bit through the Harris Code of Conduct. Can you go down in their Code of Conduct, scroll down, please? I'm sorry, I'll keep my fingers off the keyboard. There. So this is their introduction with all their different areas. What I like is, the commitment to our values, commitment to our customers and business partners, commitment to each other, and commitment to community. Now, commitment to community is not something you need, but the other parts you do at least need to reference, because this sets up the structure for it. This is an ethics policy, really. This is a mix of an ethics policy and a compliance policy, which you aren't required to have unless you do more than $5.5 million contracts that are longer than 120 days. But I recommend you have a mini version of this, pull out the salient points, or the key points of it, or you, like I said, if you do a lot of work for one defense contractor, you just adopt their policy in whole. And let's go down a page, please, Kara. In this program, the Harris thing. One more. Oh, keep scrolling there. I like the way they've got the overlap between integrity, respect, and excellence. Let's keep going. Our code of conduct, and you see their code of conduct is really pretty short. Now let's read through this if I can read it. Our code of conduct describes our commitment to all values. I'm sorry, it's too small for me to read. Summarizes the essential points. Whatever it says in there, I'm sorry, I was going to read it out, but I can't. That's an important thing to have, is to say, what is your code of conduct? Because that can be a short statement, but that means that all your employees, when they sign off on your code of conduct, have read it and understood it. And then Harris walks through a number of steps. We just walk through their slides, Kara. Making ethical decisions is one of their slides. And theirs is much more detailed, and obviously they have a lot more money to invest in this than you, and you don't need anything fancy like this. I recommend you put something on your website, and if you're not required to have a code of ethics program, I'd put in there as a commitment to best practices. We have a code of ethics, even though we're not required to FAR regulations, or FAR, whatever the FAR 52 clause was, because we have less, whatever size. But I recommend you go ahead and do that. And then it's got their resources on there. Next page. I like their pictures. I like anything from Harris, so they've got cool stuff. I've got to do this disclaimer. My sister-in-law does work for Harris, but she's a admin person. Now, let's go back to the slideshow, please, to the PowerPoint. And let's bring up the SpaceX Supplier Code of Ethics. Space Coast, SpaceX. We live on the Space Coast, so I get my terms mixed up times.
Uh-oh.
Coast is not a traditional government contractor. And a lot of their work comes under what's called other transactions, which means the FAR doesn't really apply. Which means the FAR does not apply unless specifically incorporated in their contract. But they're still bound to have an ethical business. So you'll see their contract. I'm going to take another drink. Their code of ethics is significantly different than Harris is. Let's just scroll through this one, Kara.
That's all there is, just one page.
That's it? Okay.
That's
so
it.
You can see it's relatively small. It's got signature blocks on the bottom. The SpaceX may be a good one for you to consider. If you work for SpaceX, or do most of your work for SpaceX, I'd recommend you adopt their policy altogether. They don't have as detailed a policy as L3 Harris because they really aren't a FAR compliant company since they're do business on what's called other transaction authority for the most part. Other transaction authority is really fascinating because it's a way for the government to get certain services without using the FAR and beyond the scope of our class today. Go back to the PowerPoint, please.
I just want to say something as having been a subcontracts manager. This is one document that has to be signed, dated, and usually annually signed and provided to the prime and is placed into your subcontract folder. So.
Yeah. No, Kara, thank you for making that point. I think I mentioned that earlier because when you talk about best efforts, when I talked about earlier about best efforts to comply with it, that's only going to come up in one of two circumstances. If you get an investigation or you get an audit. And if you get an audit and you're required to have these kinds of things and you don't, they can reduce the payments to you. So if Harris did not have, on an audit, did not have annual signed statements about this ethics program, the government could reduce payments under all the Harris contracts until they came into compliance. Or payments under the contract being audited. If you're not required to have it, it's not as important. But I recommend you get them every year, you get them signed, and are able to produce those records. You can do it electronically if you want and have everybody sign electronically. If you do, you need a click box or something that says, I have read and agreed to comply with it. Don't just put a signature on there if you're going to do it electronically. Have a box that each person has to affirmatively check to show that they've actually read it and not blow it off. They may still blow it off, but at least they have claimed that they have, which protects you better, gives you better protection. We're not going to go into the Northrop and the Boeing standards of conduct and ethics of compliance. I just put all of those on there as an example of what large companies are publishing as their standards so that you may be able to adopt similar ethical standards and standards of conduct. Next slide, please.
Ed, we did have one more question. Can a supplier also be a subcontractor? By Carolyn Kinzel just asked that.
Supplier is a subcontractor. We just call them different things. Subcontractors are ones that do physical work, typically, and suppliers are ones that just give you stuff. But in reality, they're both subcontractors because they're both have a subcontract, which requires them to do certain things. You know, it's interesting with terminology, and I do a lot of construction work also. In the construction work, contractor means a person that builds things. And so when you talk to construction guys that are just getting the government contract, they sometimes get confused when you talk about contractors because all construction contractors are contractors, but not all construction contractors are federal contractors. But all suppliers and subcontractors, anyone that gives you a good or a service, independent consultants, they're all really subcontractors. You've got to pass down the FAR clauses to all those people. So to wrap up, and if you've got questions, again, this is a good time to go in and write them in. We'll handle questions down. Conclusion, for government contracts, ethics and compliance are everything. You want to have good policies. You want to have written policies that reduce exposure to contract, administrative, criminal, and civil penalties. and you want to have training, enforced, and reviewed policies. If an employee has an infraction, including your executives, you don't have to fire them, but you have to write it up and have a corrective action plan. So that you show that you're constantly paying attention to making sure that all your people are doing good things in good ways and not doing anything that would damage the reputation of your company. That's really one way to look at it. Is somebody doing something that's going to damage the reputation of my business? And if they are, I'm going to fix it or get rid of them. That's basically ethics in a nutshell. I think we have one more slide after this, Kara. Yep, that's the contact slide. And this is the PTAC team. Steve, I want to thank you and Kara for providing me an opportunity to provide this webinar. And if you have other subjects you're interested in bid protests, evaluation factors, whatever that would be benefit from having a legal presentation, please let Kara or Steve know, and we'll be glad to develop those programs. I'm guessing that we'll be doing more webinars because they're a lot easier to do, and we have a lot more people that can attend by webinar than we do that can attend in person in our Orlando office, where I'm not at today. I'm in Melbourne. And Fernando, I believe, is in Melbourne also. It's kind of neat. Zoom just makes it super, super easy. So, Fernando, do you have anything you'd like to add?
No, not at all. I mean, if anybody has any other cybersecurity related questions and anything related to the CMMC, you know, I'll be available for any questions right now, or if you guys need to reach out to me, just let me know.
Okay, so we're going to leave it open right now for a chat window for people to get a chance to ask questions. Kara, did you have anything you wanted to add?
No, I just wanted to say that we just had a flyover here in Orlando for those that aren't in the Orlando area, honoring the fighter jets. We're honoring our healthcare workers. I don't think anybody could hear since you were talking, so that was good. But we do have the next slide, if I can get it to move, to remind everyone to complete the session feedback survey. It will be a link in the PowerPoint slides, and we'll also put it in the email that we send out to everyone that attended.
I'd strongly recommend that you bookmark the PTAC site, either our Orlando PTAC or your local PTAC, and take advantage of the great services. Steve and Kara and their other volunteer staff, but they have a lot of volunteer consultants that should be able to give you a good answer to basically any question that you have about federal procurement. Of course, the SBA, I really said it's about agencies. The SBA has an excellent website with lots of great information on it. They have a sample All Small Mentor Protege program template that you can use. Great stuff. Look at the SBA website if you have any questions. And Google has become very effective. Just type your government contract question into Google and see what you get. But watch out for marketing websites. You know, when I type in, for example, the Brevard County property appraiser to do a search on somebody's property ownership, I get the first four items I get are services that are going to charge me to do what I can do for free. And I have to scroll down and make sure I get the one that says BCO property appraiser. So always be careful on the internet. You do get bad answers on it. Angela asked if we're getting slides. Again, everybody is going to get the slides. If you haven't got them already, we'll resend them. And I want to thank you for all your comments today and for participating in this seminar. And again, I'll leave it open for another couple of minutes for additional questions. Steve, did you have anything you wanted to add while we're waiting for additional questions?
No, no, I think that was real good, Ed. I appreciate that. I mean, it's a good follow-up to last week. I know a lot of these folks participated last week in our introduction and overview class, and in that we always say compliance is king, and this is a great follow-up to say, well, this is what that means. So appreciate that.
Most of you aren't required to meet cost accounting standards, but we're also talking about all the accounting standards. You are supposed to have pretty good books and be able to be auditable. We're not getting into cost accounting standards. I don't talk about cost accounting. But I believe that, Steve, you do offer a program on that? Or do
We
you?
don't have it virtualized yet, but if somebody's interested in that kind of thing, we certainly can either answer your questions or get you connected to experts.
Because even if you aren't required auditable or aren't required to comply with the cost and accounting standards, there's still certain things you can't do, like you can't include alcohol in your overhead pool. So if you go out for dinner and drinks with people and you want to charge it off to your government contract, you have to take out the alcohol portion of it. There's a bunch of stuff in there that's not allowable. But I said that's the subject of another seminar. Okay, we haven't had any more questions come in, so I think I'll wrap it up. And thank you all very much for attending. And if you have any questions, either send them to Kara, Steve, or you can send them directly to me, and we will try to get you an answer as quickly as possible. And please complete the survey.
Joey Grismore has a question.
Okay, I'm sorry. Just
Well, maybe.
waiting for Joey Gizmore to type in his
Yeah.
question. And I really appreciate the questions. We try to focus these seminars more on what you need to know than what we think you need to know. Joey's question is, I recently retired as a contracting officer. Well, congratulations and thank you for your service to the government. I would be interested in some volunteer support work. To whom do I send my info? There's a bunch of places you can go. You can go to your PTAC, and Steve will get you involved in stuff. University, if you're in Central Florida, University of Central Florida, and in Brevard County, the Eastern Florida State College, both have what they call small business development centers, which aid small businesses in getting information. And then there's also the SCORE, the Service Corps of Retired Executives, which isn't focused on government contracting, but provides volunteer consulting services to small businesses. And then there's local university projects that are too numerous to mention that help small businesses. So there's a lot that you can do to help share the knowledge you've gained, and it's really a great thing to do.
Well, and there's also the Chamber of Commerce's that.
Oh, the Chamber of Commerce's, yeah.
Yeah.
Okay, I don't see anything else coming in, Kara. So why don't we go ahead and close it out?
Okay.
Thank you all for attending.
Thank you, everyone, for attending, and thank you, Ed and Fernando, for taking your time and presenting to all of us. We really appreciate it.